Hello and welcome to Immigration with Andrew. I'm Andrew, and in this video I will be discussing removal proceedings, commonly called deportation proceedings, ICE's new immigration priorities, and administrative closure. So we got some, I think, very big news last week from Attorney General Garland. News that did not really break through, especially in comparison to the DACA decision yesterday that I just did a video on. And so the decision restores administrative closure to the immigration court system. And so in this video, I want to explain what that is, what it's not, what it means, and how it's related to the DACA decision yesterday as well. Great, let's jump in. So immigration court is confined within the Department of Justice, and so immigration judges are not independent judges. They are employees of the Department of Justice, and so they follow orders like they have to. And so the head of the Department of Justice is the Attorney General. Attorney General Garland earlier this week reversed a decision from previous Attorney General Jeff Sessions with the Trump administration blocking administrative closure. And so what this new decision does is bring it back. It restores administrative closure to the immigration court system. So when somebody is in immigration court, they are in, it's called removal proceedings, used to be called deportation. Most people still refer to it as deportation, deportation court, deportation process. And so those hearings usually end, those cases end really in one of three ways. The person is removed or deported, or ordered removed or deported from the United States. The person is granted voluntary departure from the United States, which still means they have to leave. It's not a formal removal order. Or the person wins some kind of relief from removal. They win a green card, they win some sort of protection, they get asylum, for example. And so generally speaking, that's how a removal case in immigration court ends. The immigration court system, something like over 1 million cases right now, very backlogged. These cases take sometimes years, depending on the case, to wind their way through the court, to get a hearing even. And so administrative closure was a tool that immigration judges were able to use to really prioritize and manage their dockets, their caseloads. And so all administrative closure means is that the case is taken off of the active docket. So the case isn't closed. It's not terminated. It's still pending. There's just not a set hearing scheduled for that specific case. And so a really common reason to have a case administratively closed would be because the person in court was applying for a U visa. The U visas take many years because of the separate backlog. Or another really common reason for a case to be administratively closed is because the person's waiting for a decision from some sort of family member's petition that, once approved, would allow them to apply for a green card maybe in court. And other reasons too. And so this was a tool where cases could be just taken off of the active docket pending some further decision. And either side, meaning the person in court, the defendant, they call it the respondent, the person in the process of being removed, could reopen the case whenever they wanted, or the other side, which is ICE, the Department of Homeland Security, could reopen the case as well. And so with President Obama, we saw priorities for enforcing removal cases against people on people with felonies, people with certain sorts of misdemeanors, and people who had not been here for very long. And so with the change in administration to former President Trump and Attorney General Jeff Sessions, uh, that tool of administrative closure was taken away, and also the priorities were everybody. If somebody could be removed from the United States, then enforcement was taken against that person. And so, what we've seen already in these first few months of the Biden administration are a change in priorities, and it took time, but a month or so ago, the ICE agency finally formalized the priorities with instructions to the ICE lawyers around the country. So now there are three enforcement priorities. The first one, people who pose a threat to national security, people who have engaged in terrorism or espionage or activities related to those, terrorists and spies, we could say. Priority number two, people who have not been here for very long, specifically people who have not been here since November 1st of 2020. And so that's really focusing on enforcing the immigration laws against people coming from the southern border, trying to cross the southern border. And then the last priority are people with aggravated felonies, which is kind of has a special definition in immigration law, but people who have an aggravated felony on their record and also pose a threat to public safety. So if the person has an aggravated felony, but they don't pose a threat to public safety, then that person won't be a priority. So, to repeat, priorities, the current priorities, people who are terrorists or spies, people who have not been here since at least November 1st of 2020, and people with aggravated felonies on their record and also pose a threat to public safety. So what that means is if the person has been here before November 1st of 2020, the person doesn't have any aggravated felonies, or they do but they don't pose a threat to public safety, and they're not a terrorist or a spy, then they're not an enforcement priority. And so when you couple the ICE enforcement priorities with the restoration of administrative closure last week from Attorney General Garland, what we're going to see in the immigration court system are a lot of these cases being closed, being administratively closed, being dismissed. That's obviously going to have to depend on each case. But the question, I've been getting a lot of questions even just since yesterday after the judge in Texas killed the DACA program, if the dreamers, if the people who already have DACA, if the people who've never had DACA but they have an application pending or they wanted to apply, if those people are at risk of deportation. And so, we'll see what happens if there's a new administration, of course. But for the time being, if somebody has DACA, almost by definition, they're not going to be a priority because they've been here for so long and they don't have any felonies on their record. If you have a felony, you don't qualify for DACA, right? So the people who have DACA or who have not received DACA ever, but they have an application pending, or the people who would qualify but just didn't apply yet, those people are not going to be a current enforcement priority for ICE. In other words, those people do not have to worry about ICE coming to try to deport them. In legalese, those people should not have to worry about ICE initiating removal proceedings against them, enforcing the immigration laws against them. So that's big news. Administrative closure was overruled in three circuit courts of appeal, I believe the 3rd, 4th, and 7th circuit courts of appeal. And so in the states that are covered by those circuit courts of appeal, administrative closure has existed since those appellate rulings. But for the rest of the country, administrative closure went away after Attorney General Sessions took that power away from judges until last week when the new Attorney General, Merrick Garland, restored that. So it's fairly complicated. I wanted to get a video up though. This only pertains to immigration court, removal proceedings, people who are in deportation court, deportation proceedings. Administrative closure is a tool given to the judges to manage their active dockets. And so ICE is like the prosecutor in immigration court, and with ICE's new priorities taking effect, I think we're going to see, I don't know if I can say most, but I think we're going to see a lot of the removal cases going away, and the the new removal cases will be focused on the southern border, people who have not been here since November 1st of 2020, and people with, as I've said, aggravated felonies who also pose a threat to public safety. So that's big news. Please leave a comment if you have any questions about this, or shoot me a text is fine as well. Big news in the world of immigration court, but again, only in immigration court. If a person's not in immigration court, this is not news for them. Thanks for watching.